Welcome to class number 6. My name is Lucas Bowler. Today we'll be analyzing. I didn't want to use the term civil law to avoid confusion. That's why I gave it this big name, contract law, tort law, family law, and some other stuff, which is basically what we group under the term Direito Civil, right? So civil law, that's what I mean when I say civil law here, right? So basically private matters. Contract law, obviously huge subject. I couldn't even begin, this is just the basic, terms. But if you work with contract law yourself, I recommend that you're going to have to read a lot of case law, hundreds and hundreds of cases, a lot more than what's on the drive. So you're going to have to not only read case law, but case law specific to the contracts you're working with, because this is something that is litigated all the time. And it's by far what the most case law that exists is really about this kind of thing, contract law. And it's mostly going to come from lower courts. So basically you form a contract, the offeror, he makes a proposal, and the offeree, he receives the proposal, but basically both are parties to the contract, right? And they have to uphold the clauses, so the contract clauses, which are the terms of the contract. And if they don't, then there's a breach of contract. So that means the contract has been violated. So there's a breach. The terms of the contract, so when you think of a terms and service agreement, that's the kind of contract. Like I said in our first lesson, there's a lot of contractual freedom. So almost all the contracts we have here in our country are sort of an adaptation from contracts from different countries. So when you think of things like non-disclosure agreements, NDAs, those are a kind of contract, or terms of service, or even prenups, those are all contracts that are governed by contract law. The performance would be, I want you to do what's on the contract. Obviously, the general idea when a contract breach occurs today is that specific performance. So you go to court and you say, well, even though there's been a breach of contract and the other party says they can't uphold the contract anymore, I still want them to do it. So I'm going to request specific performance instead of just having that being, compensatory damages. So damages here being, some sort of money being given to compensate for the fact that the contract was breached. So yeah, breach and remedies, like I said, damages would be the monetary compensation. So which is given to someone who's been the victim of the contract breach. A mutual mistake of fact, this is interesting because it differs a little bit, but this is just something that to show you a few peculiarities. It doesn't really cover the vast field that is contract law. A mutual mistake of fact would be a mistake about the thing being contracted on by both parties, which substantially alters the nature of the contract. So this comes from the decision Sherwood versus Walker, and I have it here. Basically, it was a cow, and they both parties thought the cow was barren. So by barren, what they mean is that the cow could not produce offspring, could not have children, and that would obviously substantially decrease the value of the cow. And as you can see, it's a very old case from the 19th century. But she was not barren. She was indeed capable of having offspring. So that means that both parties were mistaken about what it was that they were agreeing upon, which is why the contract was ultimately ruled to be void. I picked this case because it's often mentioned in those LLM courses. But obviously, I think I have the list here. These are some basically just to tip your toes in the water when it comes to contract law. There's a lot of stuff we have to cover. If you really want to get serious about contract law in America, you're going to have to read hundreds and hundreds of cases. These are starting points, but be prepared to search through a lot. So you're going to want to be searching the district courts, state supreme courts, and all kinds of courts in order to find contract law which can be applied to your case. And specifically, if you live here, contract law regarding contract case law regarding contracts across international borders, so basically international trade, because there's also case law obviously regarding those contracts. Now we're going to go over to tort law. Tort law is basically when something bad happens, illegal act is committed by someone without it being a crime, and you seek to remedy it with the court. Basically, we think of it with obviously, I'm going to go into great detail about this, but you cannot translate things directly, but the closest translation would be the idea of responsabilidade civil, right? So that's what tort law is. A tort is a wrong that is caused by someone that that has to be remedied by the court. So you have negligence, liability, strict liability. Basically, you know, someone has a high risk activity and they're liable even if they weren't at fault. And it's interesting because it is a bit different, and each tort is a bit different. So, you know, negligence or intentional damages, they have different rules. The idea always being the same, you know, compensatory damages, punitive damages, exemplary damages, you know, compensatory being, you know, to make the victim whole again. Punitive, you know, make it so the person is punished and the victim feels good about it. Exemplary damages being so that other people will see how much money or how many things that the person who was convicted had to do, that they'll be dissuaded from doing it themselves, right? There are not a lot of things that come into play here. One of them being intervening causes, right? So in the 1970s, Ford was manufacturing, and this is what the case says, obviously. I'm just reading from the case. But Ford was accused of manufacturing an automobile which was defective. Basically, every time you hit it in the back, it exploded. It was called the Pinto, the Ford Pinto. According to what was alleged by the parties seeking the tort, Ford knew about the problem in the car, but they made the math, they did the math, and they considered that the paying people the compensatory damages would be cheaper than fixing the mistake in their cars. That's what was alleged. And ultimately, what the defense by Ford was is that there were intervening causes, right? Even if they had installed the protections, the car still would have caught on fire in the specific accident that led to the tort claim, and that would have been an intervening cause. So, for instance, let's say there's a crash. At the same time, someone with a flamethrower comes through and sets all the cars on fire. So that's an intervening cause, which means basically that the car would have caught on fire anyway, with or without the protections. This was ultimately rejected, but you can see it here. You can see it quite clearly. I'm not going to read it out loud. You can read it yourself. So I'm also going to make the slides available, and the case law is in the drive if you want to read it. But basically, superseding cause and intervening cause. A superseding cause is a specific kind of intervening cause. It's so unrelated to the defendant's negligence that it relieves the defendant of legal responsibility for a plaintiff's injury. So basically, the example I just gave with the flamethrower would be a superseding cause. Actual malice used to be an old standard, but that was phased out because, you know, of the complexity of consumer goods today, which would make it so that people would be entitled to basically no legal protection if actual malice was required for a tort to be filed against the company. So it tends to favor the consumer a little bit more because that's better for, you know, the consumer market. Approximate cause, basically, this is a very funny, well, I mean, it was a bit tragic to the person who suffered, but it's a bit strange to think about what happened in this case, the Palsgraf versus Long Island. Basically what happened, this person was standing in a train station, and a passenger was boarding the train, and the train was departing without the passenger, and they were helped onto the train by an employee of the train company. And as they were doing that, the employee was helping the person. He caused the person stepping onto the train to drop the bag, which had, I think, explosives. And basically, some of them went off and caused something to be damaged in the station, and that thing fell and basically injured the passenger waiting on the station. So you can see it's a lot of steps. And basically what they're saying is that it's so far often removed that it's not a proximate cause. It's too far away for it to be meant as a proximate cause. It was almost like an act of destiny, because the person was trying to sue the train company. And they're saying basically what the employee did was not a proximate cause for the wrongful tort claim. So if no hazard was apparent to the eye of ordinary vigilant, basically, you know, helping someone onto a train is not something you'd assume would lead to damages. Basically, the person was not victorious or successful with their tort claim against the train company. Well, this is an old case, of course, but in our country, would basically, when it comes to high-risk activities like this, we have a different view of liability. So, like I said, this is really more to familiarize people with the specific terminology. When it comes to applicable case law, you have to analyze your case specifically, and you have to do research on the existing case law. So really just wanted to expose you to the claims and specifically to the idea of what a tort is, because that's what really matters in this class, for you to understand what the word tort means. Right, so here's some case law. These are some important cases. Obviously, much more broad, as it goes without saying, hundreds and hundreds of cases. If you really want to work with this in an international sense, you're going to have to read much more case law in this. And you're not only that, but you're going to have to read case law that's specific to the case you're dealing with, because it's going to exist. There's so much case law in the US that whatever it is that you're dealing with in your personal practice, there's going to be probably some case law applicable to it. So really, this is just so you can learn the basic vocabulary for tort law. Family law, really very similar. I would say the biggest difference is how they perceive marriage law. There's a lot more contractual freedom in marriage law, but there's also things that we've done away with. Alimony, for instance, is much more strict in the United States than here. Here, alimony, that meaning, some money being paid to a former spouse, is only paid in exceptional circumstances, or in the United States, it's paid much more frequently. When it comes to prenups, there's much more freedom in how a prenup is shaped than here in Brazil. But those are really the only meaningful differences. I think family law is mostly the same. Adoption, the word, it's easy to understand. It basically just means, you take a child that's not yours. And a few words, for instance, legal guardian, meaning you're responsible for the child. An important thing here is to think of the Obergefell versus Hodges case, which was the case which legalized same-sex marriage. And you have things like civic unions, which are a bit different from marriage, but have similar effects. It's going to vary on a state-by-state basis, but the words I think are very famous. Marriage being the union of two people under the law. It's not something that the Constitution deals with at all, because it's something that is considered completely private. So the rules tend to be really local. The federal government really only steps in to make sure that there's no discrimination taking place. So basically, there's a law recently protecting same-sex marriage recognition in different states, almost anticipating perhaps that the Supreme Court might overrule Obergefell versus Hodges, because it's there's a very conservative court in Washington right now. As of today, when I'm talking and speaking, it still has not been overruled, so it's still, same-sex marriage is still legal and enforceable in all states in the United States. So here are a few cases. Same warnings apply. Please read more case law than this if you actually want to work with U.S. family law. Property law, this is something that's interesting. Adverse possession. Adverse possession basically means becoming the proprietor of a certain piece of property through the passage of time, because that piece of property has been abandoned. It's similar to what we call uso capião, right? But I think the difference here is cultural, because this is something most Americans are completely unfamiliar with. Even lawyers tend to refer to this as like legalized theft. And to me that's funny, because it seems that they don't really view property at all in the same way that we do. They have a very sacred view of property. So to them, the idea that the property might become yours because you live in it and you take care of it is extremely strange. And there's reflected in the legislation which regulates adverse possession, which is much stricter. It has different requirements. It has longer periods of time, and I'm gonna go into it right now. So hostile claim, it has to be a claim. This is the same thing in Brazil. It has to be claimed against the person, and you cannot have their permission to live in the house and then claim it through adverse possession. But it has to be open and notorious. So if you live in a home in the suburbs and it's abandoned, it has to be open. You cannot hide in the home and then claim it through adverse possession. And you have to take care of it. So, conduct repairs, and you have to really make it your own home. You can't just, a derogative term that is used for people who live in abandoned houses, which is squatter. So usually those claims will not be protected because those are not open and notorious possessions. They're often not continuous possessions. And they're also not exclusive. So you have to live in the home by yourself or just your family. It has to be open and notorious, and it has to be continuous. Another thing that happens is color of cattle. Basically, if you think you own the house, usually, and even though you don't legally, that usually helps you when you have a claim of adverse possession, even though it's not mandatory. So yeah, U.S. property law, case law. Here are some cases, same thing. Please read more case law on this. I believe that is all for today. This is very, very simple overview. I think most terms are familiar to people who work with civil law here. But yeah, I think most things are easy to figure out with this branch of law specifically. But we'll go over them when we analyze civil procedure. All right, so thank you. I guess I'll see you in our next lesson.